as we all know, CRPC proceedings can be divided, can be like, for our convenience, we can state it as three sector, that is pre-trial, then trial, and post-trial proceedings. So here today my session is on pre-trial proceedings, and which is just in half an hour we can just go to the intro section only. So in this session I will start my screen sharing once again. Okay, pre-trial proceedings under Criminal Procedure Code. Then the topic today which I'm going to delve is who and how is the criminal law set in motion? That's the first question we are going to deal in this session. Then second one, in order to go deeper into the topic, we should be able to understand what is cognizable and non-cognizable offense, and in same way, what are summons cases and warrant cases. So to start with, who will set the criminal law in motion? That is, how can we start the proceedings under criminal CRPC in India? Usually, we all know it may be by the victim or any person who is feeling offended or aggrieved by the crime would be the most likely to set the criminal law in motion. So either the victim or any other person who is aggrieved by the crime can set the criminal law in motion. That is, to keep it in a simple term. And coming to the pre-trial phase, the pre-trial phase of criminal proceeding, it starts, there are many steps in pre-trial proceedings. And the first step, or we can start the pre-trial proceedings by first giving the information of the offense. That is either by the victim or by any other person. We already told it. Then after that, the police investigation. That is the next step. And third step is examination of witness. Then next one, search and seizure of evidence. And the next step is arrest of accused or suspected person. And the last and the final step is filing the charge sheet before the honorable court. So these are the proceedings which we are going to deal under pre-trial proceedings under our CRPC. So today we will be just going through the introduction session, or maybe first information of the offenses, how the information is made, and what are cognizable offenses, what are non-cognizable, what is summons case, and what are warrant case. So what is cognizable offense? As you all know, Section 2 deals with the definition under CRPC, and Section 2C of CRPC defines cognizable offense. It is defined under Section 2C of CRPC. And what is cognizable offense? It's an offense in which a police officer may, in accordance with the first schedule, of CRPC. If you have a barrack, if you go through the last pages, you can see there are two schedules for CRPC. In that, the first schedule deals with the offenses, classification of offenses. So cognizable offenses is that in a case in which a police officer may arrest without any warrant, may arrest the accused without any warrant, and those offenses may be included either in the first schedule, or it may be an offense according to any law which is there in force for the time being. So according to 2C of CRPC, cognizable offenses is defined as it's a case in which a police officer may arrest the accused person or the suspected person without any warrant, and such offenses are explained in either the first schedule of CRPC or in any other law which is there in force for the time being. So this is what cognizable offenses means. So under cognizable offense, the police officer can arrest the person, the accused person, without any warrant. And Section 2L of CRPC defines non-cognizable offense. And what is non-cognizable offense? Of course, it is an offense for which the police officer have no authority to arrest the person without the warrant. And that is, without a warrant, without an authority of the magistrate, the police officer cannot arrest the person who is accused of that offense. That is non-cognizable offense, to put it in simple manner. And it is under section 156 and 157 of CRPC. We can say that in case of a cognizable offense, the police officer can arrest the alleged person or the suspected person without the warrant and can investigate into such case without any order or direction from a magistrate. It is dealt under section 156 and 157 of CRPC that under a cognizable offense, the police officer can arrest the accused person or the suspected persons or the alleged person without any warrant and can investigate into that matter without any order or direction from the magistrate. But under section 155, it is well stated that in case of a non-cognizable offense, a police officer cannot arrest any person, any accused, any alleged person without a warrant, and neither the duty nor the power. He doesn't have any power to investigate into such offense without the authority given by the magistrate. So it is clearly stated under section 155 that in a case of a non-cognizable offense, the police officer cannot arrest or cannot authorize himself to go through the investigation of that case without the authority given by the magistrate. And non-cognizable offense are, of course, from this definition itself, we can get to know that a non-cognizable offense is considered to be that of less serious offenses, that is of private wrongs. And however, if magistrate considers that it is to be investigated by the police officer by going upon the facts of such private complaint, if the magistrate feels that it has to be investigated by a police officer, he can order so, and the police officer will get all the powers in order to investigate the matter as in the case of a cognizable offense, except the power to arrest without the warrant. Okay, so in case of a non-cognizable offense, as it is of a private nature, it is less serious offense. But if the magistrate consider hearing upon the facts that it has to be investigated by the police officer, he can give an order in such a manner, and the police officer can investigate all such cases, such a non-cognizable offense, as he is investigating a cognizable offense. But only exception is that he doesn't have the power to arrest without the warrant. So these are the main points which we have to consider while dealing with cognizable and non-cognizable offense. Hope it is clear for you. And now we are going to warrant case and summons case. So what is warrant case and what is summons case? As we all know, under a definition, section 2X, it defines the warrant case under CRPC. So what is a warrant case? A warrant case is a case relating to any offense punishable with either death or imprisonment for life or imprisonment for a term exceeding to 2 years. That is, a warrant case is any case relating to an offense which is punishable with either death. There are three conditions: either death, punishable with death, or second condition is imprisonment for life, or either imprisonment for a term exceeding 2 years. It is well defined under section 2X of CRPC. This is warrant case. And so what is summons case? Summons case, as defined under 2W of CRPC, summons case is any case relating to any other offenses not being a warrant case. That is, any other cases which doesn't come under warrant case. That is summons case. Okay, by looking into the classification itself, we can see that this classification is mainly based upon the seriousness of the offense. That is, warrant cases dealing with serious offenses or heinous crimes, and the summons cases relating to less serious and trifle matters. It is under section chapter 19 and 20 and section 274, 75 and 278 of the code that describes the trial procedures for warrant and summons case. Okay, I hope it's clear till this. Now going to section 204. It is well defined under section 204. 204 defines how this warrant case and sessions or summons case should be dealt by the magistrate. According to section 204 subclause 1 of CRPC, it is well stated that while in a summons case, while a magistrate dealing with a summons case, the magistrate concerned shall issue a summons. You have to look into the term shall issue a summons, but in a warrant case, he may issue a warrant, or if he thinks fit, a summons for the attendance of the accused. So in warrant case and the summons case, how the appearance of the accused is defined. It is well defined under section 204 of CRPC. So according to section 204, subclause 1 of CRPC, it is stated that in a case of summons case, the magistrate shall issue the summons, but in a warrant case, he may issue the warrant, or if he thinks fit. It's upon the magistrate, if he thinks fit, a summons for the attendance of the accused. So I hope it's clear till this.
So, Surya,
yes,
next slide.
Yes, sir. This one?
Chapter
19 and
11, 19 and 20. So, could you explain that section 124, 125, and not just mention?
Okay, other trial procedures so I'm dealing with pre-trial and just warrant case.
Section the relevancy and
proceedings in the sections are 274, 275 and 278. Warrant and summon cases in trial proceedings.
Okay.
That's why I explain because
we will explain. We are dealing with all these sections.
I explain
I need just what is the relevance of that provision. Okay. So these are the provisions which are directly deals with the issue
trial
of
trial
pre-trial proceedings.
No, trial proceedings for warrant and summons case.
Trial proceedings. Trial. Yeah.
So that's we trial parayalo.
The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional